Okay, this is Block 100 Limited Partnership versus Fidelity National Title Insurance Company, docket number 20-241CB. This is the time set for hearing on the defendant's motion to compel for sanctions and to extend discovery. Could I first have appearances for the record?
Good afternoon, Your Honor. Daniel Bucher on behalf of the defendant.
And good afternoon, Your Honor. Melissa Hagan and George Markover on behalf of Block 100.
Okay, Ms. Hagan, your audio's really bad, but we'll try and get through this, I guess. Okay, it's pronounced Bucher, is that right?
Correct, Your Honor.
Okay, your motion, go right ahead.
Thanks so much, Your Honor. We did serve request for production of documents in October of last year, October 30th. The 28-day deadline has now expired, and I recognize that you have read everything, so I will do my best not to regurgitate that which is already written. I do want to point out to the court that plaintiff's position is that they have an entire cabinet full of documents, responsive documents that they, I think, want to give us, although they have certain restrictions placed upon the contingency of production. And to date, not a single document from whatever that cabinet is has been produced. Instead, in large part, plaintiffs have filed a written response to each request for production of document, stating they're in Lansing. I think come and get them, copy them there. I'm not quite sure what their position is regarding copying, or to pay them $2,500. We have requested, and it's in the first paragraph of our request to produce, that these documents be produced in our Battle Creek office. Mm-hmm. I've read the response submitted, and I don't believe their interpretation of the applicable court rule is correct. That being MCR 2.310. The court rule states that documents are to be produced as requested, and the responding party has the obligation to either produce as requested, which would be our Battle Creek office, or to object to the manner in which the documents are to be requested. To the best that I can see from the response, they have no objection placed to the production to our office. They simply want us to pay them $2,500 for, I'm not exactly sure what that cost is, because the court rules place upon the responding party the burden of assembly. Copying costs, I think, would be their only argument for any payment from us to get those documents. Goes not to the time, but to the paper. I have never, in responding to requests for production of documents, sent a bill back for my time spent compiling those documents. So to make things easier, especially given the COVID circumstances and MDHHS's essential work order and restrictions placed thereunder, we've asked that the documents be produced electronically. Alternatively, we've asked that they simply produce the originals to our Battle Creek office or one of our offices, and we'll handle the copying and the costs associated with that. But in any event, I don't believe the court rules place any contingency, even if the court were to conclude that copying costs were warranted here. There is no contingency or condition precedent to production based upon any of those payments. So I believe the court rules are in our favor. I believe that the documents requested should be produced either as we've requested formally in the request themselves to our Battle Creek office, and then we will handle the copying and any associated costs. Or I think under the circumstances, electronic submission would be the preferred method, though we'll leave it to the discretion of the court. But either way, we've got to get the documents one way or the other. That's why we're here. Likewise, there are several attorney-client privilege objections throughout the response. We would just ask that the court order a privilege log be ordered to be produced along with the documents so that we can see what, if anything, has been withheld, and if it needs to be addressed later, we can do that. But I unfortunately can't tell the court what I'm seeking without knowing what's being withheld in that regard. As well as the court rules do provide an avenue for reasonable costs and fees for having to bring this motion, as well as we're finally asking for a discovery extension of 60 days so that we can adjudicate the documents received and have a sufficient time to respond accordingly. Otherwise, I'll leave it to what we have written, and I have nothing further. Thank you, Your Honor.
Thank you. Ms. Hagan?
Thank you, Your Honor. I know the court has read our answer to the motion, so I will try not to repeat that. They're requesting that we produce these documents in an electronic format. And as I was looking at something else the other day, I stumbled upon a case. It's Fauner versus Delara. It's unpublished, but the court can find it at 2017 Westlaw 304-4106. It's a 2017 case, and it was brought under the Freedom of Information Act, but I believe it's analogous in this case, Your Honor, and this is why. In that case, the plaintiff there made 2 FOIA requests, and Delara responded that there's 2,358 pages and it's going to cost you $459. The plaintiff objected, requesting that Delara produce the documents in an electronic format. And the court said, we are not aware of any authority that requires a public body to create an electronic record if the record exists only in paper format. And the same is true here, Your Honor. There is nothing in MCR 2.310 that requires a party to produce documents electronically. Rather, 2.310C2 requires only that documents be produced in the form in which the party ordinarily maintains it. Similarly, MCR 2.310C5 requires that documents be produced as they are kept in the usual course of business. And so here, Your Honor, Block 100 went beyond the court rules and what is required by those court rules, and offered to convert the documents to electronic storage, but at a cost of $2,500, which we maintain is more than reasonable. In one published Michigan Court of Appeals case, Glover versus Ralph Myers Trucking, the court held that 17 cents per page was too low. The court upheld 76 cents per page. In this instance, what I did, Your Honor, to estimate the cost is I looked at a ream of paper. Here's a ream of paper, and it's about 2 inches thick. And I can fit 15 of these in one file drawer. Now there's 7 file drawers that contain the City of Lansing Block 100 case. So if you do the math at 15 reams per drawer, it's 7,500 sheets of paper. And 7,500 sheets of paper times 7 drawers is 52,500 sheets of paper. And at the standard copying charge of McClellan and Anderson, which we charge our clients at 10 cents per page, much lower than what the Michigan Court of Appeals has said is too low, that gets us to $5,250. Now, I cut that in half, allowing for duplicate documents, privileged documents, work product. And then I rounded down and I came up with $2,500. And our position, Your Honor, is that standing at a copier, feeding the pieces of paper in to the copier to put them into PDF files is the functional equivalent of copying them, for which we should be provided our costs. I've added nothing for administrative costs for the person standing at the copier. And as I've just related to the court, I think I've more than reasonably calculated the cost of copying. So that was our request. We have been more than willing for months to provide these documents, but we're asking for $2,500 to do so. On the discovery extension 2 months ago, when this issue first came up, we agreed, we'll extend discovery to February 15th. We will extend discovery, Your Honor, and we've previously agreed with that. We stand by our previous promise. What we cannot agree to, and which I do not have client authority to agree to, is any extension that's going to require the court to adjourn the trial. Finally, I was unaware from reading plaintiff's motion that a privilege log was at issue. There's nothing in the motion requesting a privilege log. Therefore, the request is really not properly before the court. But to address it, since we're here, Fidelity didn't produce a privilege log. They've raised the privilege as to certain documents they haven't produced, but they have not produced a privilege log. I say what's good for the goose is good for the gander, Your Honor. We just followed their lead in not producing a privilege log. Does the court have any questions?
I do. Are you still of the position that as an alternative, the files could be inspected at your location?
Absolutely, Your Honor.
I just want to make sure. All right, thank you. Mr. Booker, rebuttal, if you have any?
Yes, thank you, Your Honor. First to the last point, to the privilege log on our production of documents, I checked. It appears that while there were, I guess I would say, boilerplate objections based upon attorney-client privilege, which is not uncommon in response to requests for production of documents, for any documents going forward, as we have a duty to supplement, I couldn't find any documents that were withheld based upon any attorney-client privilege. So our privilege log wouldn't say anything. So we're still asking for a privilege log if indeed any are withheld as a result of the production of these documents. Now, more to the matter, there was still nothing said by Ms. Hagan regarding what the court rules require, and the court rules require production as requested. We've requested inspection and copying at our Battle Creek office. Yes, for purposes of the COVID-19 restrictions, we've asked that they be produced electronically or copied and sent over to avoid any unnecessary contact. But nothing was addressed regarding what the actual court rules require in that regard. And in that regard, we would bear everything, the cost of using our own copier, paper, and personnel. So maybe that's the best way to do it, is have them produce the originals. We'll handle the copying and everything associated with that, and we can get it back to them.
All right, thank you.
Thank you.
Well, I think what's at issue here is not just a lot of documents, it is a boatload of documents. As the plaintiff has described them, multiple drawers of a file cabinet full of documents, not just a drawer, but multiple drawers full of documents. So the defendant proposes a couple of alternatives. One is that the plaintiff is just supposed to ship an entire file cabinet out to the defendant's attorney's offices in Battle Creek and allow them custody of the originals to make copies themselves, or that they're supposed to convert the documents to an electronic format. I don't think the discovery rules require either one of those things. And I think that both of them both those alternatives are just fraught with issues for obvious reasons. One, sending a file cabinet of original documents to defendant's counsel's office is certainly not an option that the discovery rules encompass. And it's onerous indeed to require someone to take what is paper documents and convert them to electronic format. And there's nothing in the discovery rules that require the responding party to go to that kind of time and expense to do that. So what the plaintiff has said is that they can be inspected at their offices, which I think is encompassed in the court rules. And in the alternative, the defendant can pay a cost that the plaintiff has reasonably calculated to convert the documents to electronic format. I think either one of those alternatives is fine and encompassed by, if not the exact letter, but the spirit of the discovery rules, in that the plaintiff should not be burdened with really what would be an onerous burden of copying or changing to electronic format all of these documents. I recognize, the apparently defense counsel had an issue with COVID restrictions, but and I don't want to put anyone's health at risk, but I'm sure that McClellan and Anderson would make appropriate arrangements if inspection ends up being the alternative that is taken to ensure the safety of defense counsel and have minimal personal contact in inspecting the documents. And I think that's a very reasonable alternative. That alternative actually is reasonable for two reasons. One is the expense is not there. And the other is that given that this is some 7 drawers of documents, perhaps upon inspection, counsel could find that the request could be narrowed down substantially to something that would be more reasonably produced, and we would, in that way, narrow down this request. So for those reasons, and I would add too that given the nature of the documents that are being requested, I think there's almost certain to be attorney-client issues in these documents. So if any of them are held back or protected, then I think it's reasonable to require the plaintiff to do a privilege log so that that can be explored more fully. And I am not granting sanctions, but I am denying the motion to compel for the reasons that I've stated, that the alternatives and the way that the defendant wants the court to compel this production is not authorized by the court rules, and I am denying the motion.
Thank you, Your Honor.
The extension of discovery, Your Honor.
Oh, the extension of discovery, pardon me. The plaintiff wasn't opposed to February 15th. I'll grant an extension of discovery to March 19th. I don't know what the trial situation is, if it's jury, non-jury. If it's jury, we're not doing any. We're way backed up. Criminal has priority when we do start. If it's non-jury, I really don't think that a short delay like that is going to cause any harm. And there's going to be scheduling problems anyway, because once we do start doing criminal jury trials, the court's going to be pretty jammed up on the schedule. So I see no harm.
Okay. Thank you, Your Honor.
All right, thank you.
Thank you.
I will put together an order and send it to counsel.
Thank you.
Thank you, and have a good day, Your Honor.